Yes, this is Voices of the Bar, where the legal world speaks. We thank you so much for always watching the Voices of the Bar, where the legal mind speak. And today we want to straight go to the defense of accident. We want to discuss the defense of accident. When does this defense arises? When does it occur? Section 8 of the Penal Code in Uganda. And we want to go into details of what do we mean by the defense of accident. When can this defense occur? We want to know when can somebody raise this defense, and then we shall discuss one of the cases, one of the leading cases that explains what we mean by the defense of accident. My name is Walter, and this is Voices of the Bar, where the legal mind speaks. And we ask you to subscribe, to share, and always like our videos. So let's now straight dig into the defense of accident. Now, an accident, literally speaking, this is an expected danger. Danger has occurred, but is unexpected. Like, it is, you did not literally intend to have this thing happen that you have just caused. Your soul is clean, is pure. It doesn't differ from when we discuss accident in terms of the legal mind, the legal language, that this is still when something happens, but at the subconscious of your mind, you never intended. There was no intent, mens rea. You don't have the mens rea. Actually, is defense of accident means that we have failed to prove a malice aforethought. If it was for purposes of murder, their malice aforethought has not been proved. The intention is not there. So you must look at these problem questions and see, was there the intention, the mens rea? Was there a malice aforethought? Now, in the event you prove that there was no malice aforethought, then you can raise the defense of accident. You see, I never intended to do this. You understand? So, that is what we mean by the defense of accident. Let's look at the case of Wilmington versus DPP. An English case. Wilmington was separated from the wife, and while he was at work, he felt the urge that he missed his wife. He wanted his wife back to him. So he decided to go and check on the wife. Wilmington said, in order to be able to bring my wife back, let me go and scare her that if she doesn't come back to me, I am going to kill myself. You understand? So, he therefore moved. He tied a gun around his neck just to go and threaten her. If you don't come, I'm going to kill myself. If you don't come, I'll kill myself. So when Wilmington got there to the girl's home, he met the mother-in-law, the mother of the wife, and told her, the mother, where is my wife? The mother told him, she's inside. So Wilmington entered inside to check on the wife. Now, while there, he started to plead with her to come back home. Okay? Okay? He pleaded with her to come home. And he even threatened that if you don't come, I am going to kill myself. And he put a gun here. So incidentally, in the process of scaring the girl, so Wilmington incidentally hit the trigger and shot the wife. The wife fell down. Crazily, Wilmington went back to work and he worked. That's why he was found. They told him, you killed somebody. They took him to the court of first instance, the trial court, the first court, and they found that he was guilty. But while there, he raised the defense of accident. That it was an accident. I actually did not intend. You understand? Did not intend to kill my wife. So when he raised it, they found him guilty. Court ruled that he did not satisfy court that the burden was on him to prove that it was an accident. So Wilmington appealed. So on appeal, when Wilmington appealed, it was now held in the Court of Appeal that House of Lords that the burden lies on prosecution to prove whether it was an accident or not an accident, and therefore Wilmington was acquitted. An indication that means that the defense of accident occurred, that they failed to prove the intention, the malice. So that malice aforethought was not there. This guy had come to plead. He had come to plead for his wife. You understand? Now, there's no way somebody who has come to plead will kill. Okay? So, that defense of accident in the case of Wilmington stood where there is no mens rea, where there is no malice aforethought, then that means that, yes indeed, this person can raise a defense of accident that they never intended to kill the deceased at that particular time. So that is what we mean by the defense of accident. You raise it if what you've done was unintentional. You didn't have the bad motive. You didn't. The ill motives are not with you. Where prosecution fails to prove mens rea and then malice aforethought, then automatically the defense of accident will arise in that particular scenario. We thank you so much for watching the Voices of the Bar, where the legal world speaks. Subscribe, share, and like our videos. See you next time. This has been the Voices of the Bar, and we have just discussed the defense of accident. Thank you. Until next time, cheers.